Green card at risk? 2026 travel mistakes that can ruin your status. Picture this. You've just landed at JFK after a 3-week trip abroad. You're tired. You're carrying gifts for your kids. You're already thinking about getting home. Then a CBP officer pulls you out of the primary line. A second officer appears. Then a third. They take your green card. They take your passport. They sit you in a room with cold fluorescent lights and no clock on the wall. The questions start simple. How long were you gone? Where did you stay? Why did you go? Simple questions. But they're not simple at all. This didn't happen over months of back and forth. It happened in 45 minutes. 45 minutes that threatened to undo 15 years of building a life in the United States. 45 minutes that could cancel a green card that cost years of waiting. 45 minutes that could separate a family that had done everything right. One wrong answer in that room, and you could be placed in removal proceedings before you ever see your home again. What this traveler didn't know crossed a line that CBP had been watching for. And when that line was crossed, the officers did not hesitate. They responded with documentation, authority, and a process most green card holders have never even heard of. Most people panic in this moment. They over-explain. They contradict themselves. They volunteer information that destroys their case. They fall straight into the trap. But today, you're going to do something different. For several months now, there had been signals, not from USCIS press releases, not from official policy memos, just signals that CBP and immigration enforcement were preparing something more aggressive at ports of entry. Something that would catch long-term green card holders off guard in ways no one expected. CBP has always had the authority to question returning residents, yes, but also increasingly precise in how they use that authority. Their enforcement has followed a pattern, a quiet gathering of data, a targeted selection process, almost a strategic patience. But what triggered concern among immigration attorneys this year was that the usual public signals suddenly went quiet. Immigration lawyers who monitor enforcement trends at major airports recognize the indicators. The uptick in secondary inspections reported by clients. The new questioning protocols circulating in traveler forums. The sudden increase in deferred inspection, notices handed to green card holders who had traveled internationally. The shift in how officers are treating trips that used to pass without comment. And when enforcement goes quiet in its public messaging while the secondary inspection numbers rise, something significant is already happening on the ground. Early in 2026, travel records reviewed by immigration attorneys revealed what practitioners described as a measurable escalation in green card abandonment findings, including automatic triggers for absences not flagged this aggressively in over a decade. These are actions CBP takes only when signaling something specific. That a resident's ties to the United States are being formally questioned. That a reentry permit was required and wasn't obtained. Or that a pattern of behavior over multiple trips has built a case for abandonment that the traveler never saw coming. Observers in the immigration legal community weren't sure whether these cases represented a new directive from above or aggressive individual officer discretion, or whether both were operating at the same time. But one thing was clear. CBP was changing its posture at ports of entry for green card holders. And when that happens without public announcement, the people who pay the price are the ones who never knew the rules changed. The risk issued to permanent residents in 2026 is not theoretical. It is not symbolic. It is documented, and it is urgent. Immigration attorney after immigration attorney has described the current enforcement environment as unpredictable, aggressive, and most importantly, retroactive, meaning officers are looking backward at your entire travel history, not just your most recent trip. That changes everything. A 6-month trip that was technically within the legal limit 5 years ago can be used today to establish a pattern. That pattern can be cited as evidence that you never truly intended to make the United States your permanent home. And once that determination is made, the burden falls on you to prove otherwise in a secondary inspection room without a lawyer under pressure. Strategy only works if the other side hesitates. Informed green card holders do not hesitate. They know their records. They know their rights. And they know exactly what to say and what not to say. The response of a prepared permanent resident is among the most powerful defenses available in this system. Let me break down exactly what is putting green cards at risk in 2026 and what you need to know before you book your next international trip. The first and most misunderstood rule is the 6-month threshold. Many green card holders believe that as long as a single trip stays under 6 months, they are completely safe. This is wrong. CBP does not look only at individual trips. Officers look at your cumulative pattern of travel. If you have taken multiple trips of 5.5 months each, back to back, with only a few weeks in the United States between them, that pattern can be used to argue that you have abandoned your residency, regardless of whether any single trip crossed the 6-month line. The second major risk in 2026 is the reentry permit gap. If you knew you were going to be outside the United States for more than a year, you were supposed to apply for a reentry permit before you left. This permit must be applied for while you are physically in the United States. You cannot apply from abroad. Many permanent residents either didn't know this, knew it too late, or assumed their green card alone was enough protection. It is not. A reentry permit is not a guarantee of readmission. But traveling for more than a year without one is one of the strongest signals CBP can use to find abandonment. The third risk is what happens at the border when you return. Officers at ports of entry have the authority to issue a Form I-407, a document that formally records the abandonment of your lawful permanent resident status. This form can be presented to you in a secondary inspection room, and you can be pressured to sign it. You are not required to sign this form. Signing it voluntarily gives up your green card permanently. If you sign it, it is treated as a voluntary relinquishment, and your ability to challenge that decision becomes significantly more limited. If you refuse to sign, you have the right to request a hearing before an immigration judge, where you can present evidence that you did not intend to abandon your residency. This is one of the most important pieces of information a green card holder can have. And most people find out about it only after they've already signed. Now let's talk about what CBP is actually looking for when they pull you into secondary inspection. They're building a picture of your intent. Intent is the legal standard for abandonment. The question is not simply where you were. The question is whether the United States was your true and permanent home, even while you were abroad. Officers look at several factors to answer that question. They look at how long you were gone. Any trip approaching or exceeding 6 months is a flag. Any trip over 1 year without a reentry permit is a near-automatic basis for questioning. They look at your ties to the United States. Do you have a home here? A job? A bank account? A driver's license? Are your children enrolled in school here? Is your family here? They look at why you were abroad. Medical treatment for a family member is a strong justification. Long-term employment in another country is a serious risk factor. Living with a spouse or parent abroad for an extended period raises questions about where your real life is centered. They look at your tax history. If you filed taxes in another country as a resident of that country while holding a U.S. green card, that can be cited as evidence that even you treated another country as your home. They look at your prior travel pattern. This is where the cumulative picture becomes critical. One long trip might be explainable. A repeated pattern of long absences with minimal time in the United States tells a different story. I want to address something that comes up constantly in communities where this is being discussed. Many permanent residents believe that if they just stayed under 6 months per trip, they will never face any of these problems. They plan their trips with this number as the only metric they track. They leave with confidence and return with confidence. And then they sit in a secondary inspection room for the first time and realize that the 6-month rule was never the full picture. The truth is that U.S. immigration law does not define a specific length of absence that automatically terminates a green card. The 6-month threshold and the 1-year threshold are enforcement benchmarks. They trigger scrutiny. They shift the burden. They make your case harder to defend. But they're not the only way to lose your status. What matters, legally and practically, is whether you can demonstrate that the United States was your permanent residence, that you left temporarily for a specific reason, with the intention of returning, and that your life remained anchored here. If you can show that, even a long trip can be defended. If you cannot show that, even a short trip can raise questions in the current enforcement environment. Here is what you need to do before your next international trip. Before you leave, document your ties to the United States. Keep copies of your lease or mortgage, your utility bills, your bank statements, your employment records, your children's school enrollment. These are the documents that prove your life is here. If your trip will be longer than 6 months, apply for a reentry permit before you leave. Do not leave the United States without it if there is any chance you could be delayed abroad. Family emergencies, medical situations, visa complications in the country you're visiting, these things happen. A reentry permit gives you documented protection. If your trip will be longer than 1 year, which a reentry permit can cover for up to 2 years, understand that you still need to demonstrate intent to return and maintain your U.S. ties during that period. Keep a written log of your time abroad. Why you went, what you were doing, what kept you longer than planned if that happened, dates, locations. A simple document you keep in your records can be the difference between a successful return and a secondary inspection that goes badly. And if you are stopped at the border, do not volunteer more information than you are asked for. Answer the questions asked. Be truthful, but do not over-explain. Do not contradict yourself under pressure, and do not sign any document you don't fully understand. If a CBP officer presents you with a Form I-407, you have the right to decline to sign. You have the right to request a hearing before an immigration judge. Invoking this right is not an admission of wrongdoing. It is the legal process working as it is designed to work. I also want to address what is happening for green card holders who have already made some of these mistakes in recent years. If you have a travel history with multiple long trips, or if you spent an extended period abroad in the last few years, the time to prepare is now, before your next trip, not when you're standing at a port of entry. Consulting with an immigration attorney to review your travel history and assess your risk level is not an overreaction. It is exactly what the current enforcement environment calls for. An attorney can help you understand whether your travel pattern raises a red flag, what documentation you should gather before you travel again, and what options exist if your status is challenged. Some permanent residents in this situation may also want to explore whether they are eligible to apply for naturalization. If you have maintained continuous residence, met the physical presence requirements, and built your life here, becoming a U.S. citizen eliminates the travel vulnerability that a green card carries entirely. A citizen cannot lose their status for being abroad too long. A permanent resident can. That distinction matters more now than it did even 5 years ago. The 2026 enforcement environment for green card holders at ports of entry is not the same environment that existed when you received your card. The rules have not changed, but the scrutiny has intensified. The thresholds have not moved, but the pattern analysis has become more thorough. The authority was always there. The will to use it is more visible now. That is not a reason for fear. It is a reason for preparation. A green card is one of the most valuable immigration documents in the world. It took years to get. It represents a life built in the United States. Protecting it is not complicated, but it requires knowing exactly what the risks are and taking deliberate steps before those risks become a crisis. As 2026 continues, more cases will emerge. More green card holders will face questions at the border they were not prepared to answer. More families will be separated by a process they didn't know existed until they were already inside it. But one thing is already clear. Knowing this right now does not make you a suspect. It makes you prepared. It means you understand the system you are living inside. It means you can protect the status you worked years to earn. Share this video with every permanent resident in your family. Send it to your friends. Post it in your community groups. It might be the most important thing you do for someone you love this year. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase unfolds.